From West Virginia Public Broadcasting.
Support for the Legislature Today has been provided by the following. The High Technology Foundation, headquartered at the I-79 Technology Park in Fairmont. Online at wvhtf.org. Connecting West Virginia families and businesses through high-speed internet services. Learn more about connecting at frontier.com.
At the Legislature today, the House of Delegates has a new major committee at this session. The Health and Human Resources Committee now gets to meet more often to take up important legislation on the welfare of the state's citizens. And we'll begin a week-long discussion about prison overcrowding and what remedies the governor and the legislature are undertaking to ease the pressure in the state's jails and prisons on the Legislature today. Good evening, I'm Beth Voorhees. A special Senate Judiciary Subcommittee took on two bills this morning. One to revise a statute already on the books dealing with photo and video lineups for police, and a second new bill that takes on the provocative images of minors through text messages. The subcommittee heard from their own counsel on the implementation this morning, but also heard from those who will have to enforce the new and changing laws, members of the West Virginia State Police. Ashton Mara reports.
The first order of business for the Senate Judiciary Subcommittee this morning was Senate Bill 205, a bill that prohibits juveniles from possessing and manufacturing nude or partially nude photos of minors. The bill also prohibits further dissemination of the images. Because of advancing technology, it's a problem members of the state police say they're dealing with on a daily basis.
Those photographs are being shared with other people that they weren't intended to be shared with. There's students who have been, and children who have been blackmailed or extorted or otherwise bullied because of these images in fear of they being disseminated out to even further people. And what we want to try to do is we want to have the ability to work with the legislature and pass a law that's going to give us the ability to hold those accountable who are exploiting our children.
But White says there is no current code to deal with these types of offenses. The State Police Crimes Against Children Unit handles investigations involving adults who may make or possess provocative photos or videos of minors, but there is no statute to deal with distribution by juveniles. The proposed bill sent to the subcommittee provides first offenders proven guilty be committed to the custody of juvenile services for up to 6 months, and second-time offenders for a period of up to a year. The subcommittee's counsel said after speaking with a circuit judge, he thought it best to amend the bill, leaving the punishment up to the discretion of the court.
It's going to make it fair because the judge, under the circumstances, depending on what the factual situation is, has much broader discretion than what they would have had before.
Cookman, a former circuit court judge, says he's had no personal experience with sexting because the issue is so new, but agreed with White that advances in technology are forcing state lawmakers to take on the issue. The second bill taken on by the subcommittee this morning had less to do with changes in technology and more with updating a current system by which a suspect is identified. The Eyewitness Identification Act deals with photo or video lineups, much like those many of us are used to seeing on television crime dramas. The act was originally passed in 2007 to set standards to protect the innocent after a task force of law enforcement officers, court officials, and victims' advocates was formed to study the issue. White says since then, law enforcement officers around the state have followed this code, but the amendments proposed this morning create more stringent steps by which such investigations shall be conducted and holds the investigator to a higher standard.
Ultimately, that photo lineup, for it to be used in a court of law, has to pass suppression through a judge. The judge has to make a determination if that lineup was used appropriately and in accordance with the established guidelines. Our concern is simply if a very strict protocol is set in place and one of those steps are not met and it's written into code as a step that has to be taken, then you're basically taking your time in law enforcement's hands and your time in the judge's hands from being able to make a articulation as to why the police officer took action in a certain sequence of events to ultimately led to the photo lineup being used in court or being suppressed.
Cookman says he realizes it will be a more daunting process, but he says officers are often called upon to meet a higher standard, as they were when Miranda rights were put in place. He says the intention is to make sure the process is fair for the accused and that the innocent are protected.
It will make it more difficult. It will make their jobs more difficult. It will make it easier for a defense counsel to suppress these type of procedures. But the balancing act is whether or not in the end it's fair for the accused and with the officers also having the ability to investigate their cases.
White says the state police will carry out the will of the legislature, whether they agree with the passage of the bill or not. He says he and fellow officers will return to address and take questions from the full committee on the issue. On the floor today, the Senate unanimously passed two bills, Senate Bill 172 relating to beer distributor licensees and Senate Bill 196 dealing with expiring funds and supplementary appropriations. They moved 5 bills forward from second to third reading without amending and introduced 16 new bills. For the Legislature Today, I'm Ashton Mara in the Senate.
With major issues related to health around the state, the House Committee on Health and Human Resources is the key player in deciding what related legislation makes its way to the House floor and up for passage. Dave Mistich takes a look at this committee and why House Speaker Rick Thompson elevated the committee to major status so it could meet more often.
The committee quickly tackled 10 rules bills before moving on to 2 pieces of legislation introduced this session, both of which received extensive amounts of discussion during the meeting. The first was House Bill 2729.
The purpose of this bill is to allow an epinephrine auto-injector to be maintained in schools for emergency treatment administration during anaphylactic reactions. It permits ODs and MDs to prescribe standing orders and protocols for use when necessary by the schools. It permits school nurses and trained non-medical school personnel to administer. After use of a student, the school shall identify and notify the parent. It provides immunity to civil liability to school nurses and trained non-medical school personnel unless that act or omission constitutes gross negligence or willful misconduct.
Delegate Joe Ellington of Mercer County is the minority chair of the committee. He explains another bill discussed in the meeting.
So the second bill was House Bill 2327, which would allow the elected sheriffs and counties access to the drug database that's available to the state police at this time. Significant debate is going to center around elected officials being able to have access to personal information. Currently, they have access to the state database through a liaison with the state police. From the legislative standpoint, we're trying to find out if there's been any barriers to them achieving that or accessing that information. Our concern is also we don't want someone just to be able to peruse personal information on a lot of people and use it for any political or personal gain.
A more thorough discussion of those bills is a direct result of the House Health and Human Resources Committee being elevated to a major committee this past November. Delegate Don Perdue is the chair of the committee. He explains what the switch to major status means for his group and the legislation they consider.
Well, what it does is it gives us a greater amount of time to work the bills that we have, the very complex issues regarding health, especially nowadays. It gives us extra staffing to a degree, and it enables us to look at legislation that heretofore we couldn't because we just didn't have the resources to do so. Now we can, and it has really improved our ability to act on behalf of the citizens.
Delegate Ellington agreed that the committee's elevated status was needed and added that there are a lot of issues relating to health around the state that deserve the committee's attention.
If you look at the budget for the state, between education and health, that's about 2/3 of the state budget right there. So health, and with the Affordable Health Care Act coming into effect this coming year, the role of the health department is probably going to be a significant player as far as what happens within the state. Other issues, sort of like these 2 bills, are indicative of things to come. I think we have a lot of issues, especially with the drug history of the state, that we're trying to combat that from multiple fronts. That's going to be a big player regarding the health department.
House Bill 2327, which would add county sheriffs or a designee to the law enforcement officials who are granted access to certain confidential pharmaceutical information, was laid over until the committee meets again. House Bill 2729, which would allow schools to voluntarily maintain and use epinephrine auto-injectors, was recommended for passage and sent to the Judiciary Committee for second reference. All 10 rules bills were also referred to the Committee on the Judiciary. For the Legislature Today, I'm Dave Mistich in the House of Delegates.
In a moment, we'll begin a week-long discussion about prison overcrowding and what to do about it. First, here's a look at some of the bills introduced in the Senate today. Among the bills introduced in the Senate today, Senate Bill 417 to create a drug testing program for applicants and recipients of temporary assistance for needy families cash benefits and for recipients of unemployment benefits. The bill provides for mandatory drug testing for members of the legislature. Senate Bill 420 to create the Firearm Protection Act that provides that any federal law effective after March 1, 2013, which attempts to ban semi-automatic firearms or to limit the size of a magazine of a firearm or other limitations, is unenforceable in West Virginia. Senate Bill 421 to provide an exemption for the official mascot of Parkersburg South High School, commonly known as the Patriot, which would allow the mascot to carry a musket on school grounds when acting in his or her official capacity. This is the same exemption that's granted to the West Virginia University Mountaineer. Senate Bill 423 to include those sentenced to 6 months in regional jails to be eligible for good time credit. Senate Bill 424 to terminate the state's jurisdiction over reclaimed, bond-forfeited surface mining operations if the land reclamation was completed. Senate Bill 425 to provide mental health treatment alternatives to involuntary commitment. And Senate Bill 428 to remove the prohibition on billing persons for HIV testing or testing for sexually transmitted diseases conducted by the State Bureau for Public Health or county or local health departments. The bill allows public health agencies to charge patients or their medical insurance providers for the reasonable costs for testing. Up for passage in the Senate tomorrow, Senate Bill 47 to revise the antiquated stock laws of West Virginia. Senate Bill 194 to repeal the purchasing exemption provided to the Medicaid program. Senate Bill 214 to clarify the requirements for obtaining a license to practice medicine and surgery or podiatry by making personal interviews of applicants optional at the discretion of the Board of Medicine. Senate Bill 335 to permit certain hospitals to request an exemption from certificates of need for healthcare facilities in specific instances. And Senate Bill 338 to codify existing common law in West Virginia as it relates to the duty of care possessors of property owe trespassers. On second reading, Senate Bill 101 to provide technical cleanup to clarify that the legislature originally intended that all actions brought against a nursing home are subject to all the limitations and provisions set forth in the Medical Professional Liability Act. Corrections officials warn that prison overcrowding is at the crisis stage. They've been saying that for years, and the governor and the legislature are turning their attention to the issue. To that end, officials turned to the Council of State Governments, which drew up a report entitled Justice Reinvestment in West Virginia. It contains analysis and policy options to reduce spending on corrections and reinvest in strategies to increase public safety. Joining us tonight is the chair and vice chair of the Senate Judiciary Committee. Senator Corey Palumbo is an attorney from Kanawha County. First elected to the House in 2002, he was elected to the Senate in 2008. And Senator Gregory Tucker is an attorney and businessman from Nicholas County. He was elected to the Senate in 2010. Gentlemen, welcome. Glad you're here.
Thank you for having us.
Now, there are those who would say, so what if prisons are overcrowded? There are criminals. They need to be locked up. Too bad. There's too many. Too bad. Why should we be so concerned about prison overcrowding?
Well, the issue is, do we want to spend another $200 million on building an additional prison? Or do we want to try to be a little bit smarter about how we deal with people in our correctional system? Mm-hmm. So there is an impact on people who aren't criminals in that, that money comes from taxpayers. Mm-hmm. And do we want to spend more money right now than we already do, or do we want to try to rein that in a little bit mm-hmm. and still get better results in our outcomes?
Are overcrowded prisons dangerous places?
Oh, certainly they can be dangerous. You know, one of the points that you have to consider when you're dealing with prison overcrowding, in addition to the situation that the prisoners are in, but also the employees of that prison. But one thing that you have to also consider in the prison overcrowding issue is that these folks are in need of some sort of treatment and not getting that. They're stacked in our regional jails and they can't move into the prison system where they get the programs that they need so they can become contributing members of our society again.
This is the Justice Reinvestment in West Virginia report from the Justice Center for the Council of State Governments. It's very complete, comes with great recommendations and rationale for those recommendations. How much of this report made it into Senate Bill 371, which is the governor's bill to address prison overcrowding?
From what I can tell, virtually everything from the report is in the governor's bill. There may be some small things that aren't there, but all the significant key recommendations from the report are contained in the governor's bill.
What recommendations?
Well, I think there are several things key things that really would address the issue. One is taking a different look at how we address parole violations. I mean, minor technical sort of having a graduated scale for how we deal with parole violations and not throwing everyone who has a technical parole violation back into the prison system, but having a gradual scale on how we deal with those. Two, trying to divert more money and more emphasis on drug treatment, having a sort of a continuum of care for folks who, when they get in our system, they get treatment and care that they need to try to become productive members of our society. And the third key part that I consider a key part of the bill is ensuring that people who come out of our correctional system end up going back into society with some supervision. Right now we don't have that. We're talking about having people released from our system possibly 6 months before they otherwise would have when they're going to term out 6 months early, but with supervision. And what that's shown in other states when they've implemented this is that supervision significantly reduces recidivism rates. Because most people who, if they commit another crime, do so in the first 6 to 12 months. With supervision, they're much less likely to commit those crimes.
So rather than just letting them out of prison after their sentence is over, with no supervision at all, you're saying maybe 6 months early so that they can be under supervision.
That's right.
Rather than just opening the door and letting them out.
That's right. And one of the things that struck me that the folks at CSG from the Justice Center told us was that on our nonviolent offenses, so to speak, if our average sentence is 3 years, the national average is 2 years. So we're already on the high end of what we're doing with some of these offenders anyway. So if we reduced it by 6 months, we'd still be above average. And then we get the supervision piece, which would be very helpful on recidivism.
But part of the problem is that our people incarcerated are serving their time without getting the benefit of any of these programs. So if we can do that, the treatment programs, and then get them supervision once they're released, I think that we'll be much better off, and they'll be much better off, certainly.
There is some sort of substance abuse treatment in our larger prisons, correct? Not in the regional jails, but in the larger. Why not put them in the regional jails?
Well, we certainly would like to do that, and that's one of the things that we've talked about, and that's one of the things we've looked at. Right now, though, the bigger issue with regional jails is there's 400 to 500 inmates sleeping on the floor every night. We've got to address that.
What about, there was some sort of, if I can describe this right, an assessment of people as soon as they come in contact with the Division of Corrections. That is, assessing at the front end what their crime was, what their mental health issues are, you know, where they should be placed, if they should be in prison or a day center or home confinement, something like that. That seems to be working smarter up front.
Right, and I think that's another one of the important pieces of this legislation is to try to have a standardized assessment tool on the front end to try to determine what's best for folks in the system to get them on the way out to be productive members of society. I mean, the prison system's designed for punishing bad behavior, but we also want to reform behavior, and when they get out, we want them to be productive members of society.
What's the role of prosecuting attorneys in terms of prison overcrowding and sending people to prison?
Well, you have to look at when you initially get a police report, you have to look at how you charge someone as well.
And you've been a prosecutor.
I've been a prosecutor, and prosecutors have to make tough choices, and prosecutors have tough jobs now. It's going to be they're going to be a big part of how we solve this problem. But it's not just for the prosecutor, it's not just a prison overcrowding problem. They're dealing with abuse and neglect cases. I mean, it's just overwhelming on them, and we're taxing our system to the point where it's just become almost overloaded.
Mm-hmm. What about judges and their role here?
Oh, I think the judges have a big role in this. I mean, ultimately, they're the ones that are making the decision on what happens with these individuals. So they have to be a big player in this game.
Mm-hmm. What about sentencing laws? Do we need some sort of uniform sentencing law to curb or give judges, we've heard about judges' discretion, but to, somehow limit. You want to get tough on crime, of course, and you want to be tough on crime, but are sentencing laws needed here, or a revision of sentencing laws needed?
Well, I think ultimately we need to look at that. I don't think that's part of the governor's bill, and I don't think that'll be part of this legislation. But ultimately, we want to make sure that our sentencing laws are not out of line with other states. I mean, I'm sure we have some crimes in our code where our sentences are lighter than other states, but I think we have quite a few that are heavier and more heavy-handed than other states. And I think that we really need to look at that whole picture at some point. It's not going to be in this bill, but I do think that's something that we need to address as well.
That's a good way to put it. Thank you for putting it that way. A little heavy-handed with some offenses. That needs to be looked at, but it's not a part of this effort now. When do you think you'll start taking up Senate Bill 371 and holding meetings and considering passing it out of your committee?
That's going to start tomorrow. Will be our first meeting on 371. I think it'll be more of a discussion so everyone's up to speed. We already had a meeting a couple weeks ago with the folks from CSG who explained their work and their recommendations, which is essentially this bill. But we'll go into the committee tomorrow and start our discussion about it.
Can you get it done in 60 days?
Oh, I think absolutely.
You can?
Absolutely.
Senator Corey Palumbo and Senator Gregory Tucker. Very good discussion, and thank you very much.
Thanks for having us.
Thank you for having us.
And here's a look at some of the bills introduced in the House today. Among the bills introduced in the House today, House Bill 2801 to create the West Virginia Infrastructure Emergency Response Act of 2013. It provides exemption from requirements for business and employee taxes or other criteria for purposes of certain state and local taxes, licensing, and regulatory requirements on a temporary basis for out-of-state employees and businesses that provide resources and personnel during a state of emergency declared by either the governor, the legislature, or the President of the United States. House Bill 2804 to create enhanced criminal penalties for assaults or batteries against pregnant women where the perpetrator knows or has reason to know that the victim is pregnant. The bill creates both misdemeanors and felonies. House Bill 2806 to require that a prisoner exhaust administrative remedies prior to bringing a civil action. An administrative remedy is a process whereby a prisoner presents concerns relating to all aspects of prison life. House Bill 2809 to authorize a responsible parent pilot project by the Division of Corrections in an effort to improve child and family well-being and to empower men and women with the skills and resources needed to succeed as parents and as family providers. House Bill 2811 to prohibit convicted felons from holding employment positions that provide them with access to medical, financial, or other confidential information of clients or patients of the employer. And House Bill 2814 to provide assistance to victims of human trafficking. Just one bill on second reading in the House tomorrow, House Bill 2585, to increase from 5 days to 15 business days the amount of time in which a petition may be filed after a property owner receives notice of an increased assessment of real property. This has been the Legislature Today. Tomorrow, we'll continue looking at remedies for prison overcrowding and talk to the chair and vice chair of the House Judiciary Committee, Delegates Tim Miley from Harrison County and Tim Manchin of Marion County. We welcome your questions and comments about the issues at this legislative session. You can email us at feedback@wvpubcast.org. And you can catch past full episodes of the Legislature Today on that website. I'm Beth Voorhees. Thanks for joining us. Good night.
Support for the Legislature Today has been provided by the following. The High Technology Foundation, headquartered at the I-79 Technology Park in Fairmont. Online at wvhtf.org. Connecting West Virginia families and businesses through high-speed internet services. Learn more about connecting at frontier.com.